Good evening. The Supreme Court recently ended its 2005 session with two rulings on the last day of the session, June 27th, with issuing apparently contradictory rulings in two cases of Ten Commandments monuments on display on public property. Tonight, we're going to examine those cases and try to ascertain what the implication is going to be for the security of the wall of separation between church and state. This is Atheist Talk, and I'm George Kane, the chair of Minnesota Atheists, and my guest tonight is August Berkshire, the public relations representative for Minnesota Atheists. August, welcome.
Thank you, George.
Why don't we start with the McCreary County versus ACLU case, which was decided in our favor, we'd say, the favor of the First Amendment Establishment Clause. Could you review that for us?
Yes, well, this was McCreary County versus the ACLU of Kentucky. And you had two courthouses in this county in Kentucky, and each had put up a Ten Commandments plaque on their wall, which was very visible to anyone going in and out. Well, this was found to be unconstitutional by the lower courts, who's clearly promoting religion. Well, then they tried another angle, and they put up other documents on the wall. But these documents had specific references to religion. That's what they all had in common, things like the Mayflower Compact, for example. And so, again, this was found suspect. It was an endorsement of religion. Well, the courthouses tried a third time, and this time they took away some of the previous plaques and substituted others, so that now they tried to say that this was a secular display because it not only had the Ten Commandments, but it had these other things like the Constitution. However, this went to the Supreme Court, and the Supreme Court said no, the motive of these displays was clearly religious. And so they're unconstitutional. You have to take them down.
Now, how did they determine that the intent was religious?
Well, they looked at the secular purpose, whether there was a secular purpose to these monuments or not, or these displays of plaques. And they found that the commandments are a distinctly religious document believed by many Christians and Jews to be the direct and revealed word of God. Now, even in the display with these other secular plaques, they said that the effect of this display was still to endorse religion, that one religious code placed alongside 8 political or patriotic documents, the counties promote that one religious code as being on a par with our nation's most cherished secular symbols and documents. So you couldn't secularize the Ten Commandments. In fact, by putting in these other documents, it sort of elevated the Ten Commandments to the status of the secular law. So it was still unconstitutional.
All right, well, that will raise the question of why it's not unconstitutional in every case, but we'll get to that question later on.
Now, it was interesting that the Christians that were promoting this display of Ten Commandments plaques said that the Ten Commandments were somehow the foundation of the Declaration of Independence. Anyone who's read those two documents will see absolutely no connection. And in fact, the Supreme Court said that the counties offered no support for their claim that the Ten Commandments provided the moral backdrop to the Declaration of Independence or otherwise profoundly influenced it. So they couldn't get away with just claiming it was an influence. They never proved it. Mm-hmm. So that was another reason it was struck down.
Right, that's especially true, I would think, that because the Ten Commandments are supposedly valid because they're authored by God, whereas the Declaration of Independence placed the legitimacy of government in the will of the people.
In fact, the court pointed that out. Let's see, we'll get to that. Exactly, they said the commandments are sanctioned as divine imperatives, while the Declaration of Independence holds that the authority of government to enforce the law derives from the consent of the governed. So, as you say, the Ten Commandments are completely at odds with the Declaration of Independence. One is top-down and one is bottom-up.
Right.
The Supreme Court made reference to a 1980 case known as Stone, where you had Ten Commandments plaques in public schools, and they had ruled that as unconstitutional. So they referenced back to that. Let's see. They also said that by showing a purpose to favor religion, the government sends the message to non-adherents of the religion, that they are outsiders, people like you and I, outsiders, not full members of the political community, and an accompanying message to adherents that they are insiders or favored members. So that's why the government cannot endorse religion, because it divides the population and favors. I mean, a non-Christian walking into that courthouse, or a non-Jewish person, and seeing the Ten Commandments might say, well, what kind of justice can I get here if a Buddhist walking in, a Muslim, an atheist? What kind of justice can I get in this court that's supposed to be neutral when I see them endorsing the Ten Commandments?
Right. I think Breyer, as I recall, was especially sensitive to the divisive nature of religion today, that the First Amendment should be serving to avoid the divisiveness that can tear a society apart and has so many places in the world.
The Supreme Court brought up the Lemon Test,
Right.
1971, so-called Lemon Test, which says that a government action must have a secular purpose. Now, it noted in this case that although the legislature, when they were putting up these plaques in the Kentucky courthouses, said they had a secular purpose. And the Supreme Court said that although a legislature's stated reasons will generally get deference, the secular purpose required has to be genuine and not a sham. And they said that just claiming that the Ten Commandments are secular doesn't make that so. In fact, they're not secular. There's not a secular purpose. It was clearly a religious purpose from the beginning.
All right. Well, that's an important point.
Yeah.
Clearly, on what basis?
The basis is that the first display had only the Ten Commandments.
Okay.
And when they couldn't get away with that, they threw other plaques up, which also pointed to God, but they thought they could sort of water it down and obscure it. Well, no, that was clearly a religious purpose, too. And then finally, seemingly in desperation, they threw in a few secular documents.
Okay, but isn't it also the case that the court actually looked at the legislative record and the testimony and what was said when the decision was being made to put up the commandment display, and that the legislators were calling for recognition of our Christian heritage explicitly? And so one way to determine intent now is to look at what the legislators or administrators said when they put the monument up to determine what the purpose is.
Exactly, and that was sort of reminiscent of the creationist case from like 1986, when they were trying to teach creationism down south, and it became apparent from the legislative testimony that it was to advance God. And so that's another way they can determine intent. Well, just to kind of finish off this case here, the Supreme Court stated that the Ten Commandments proclaim the existence of a monotheistic God and no other gods. They regulate details of religious obligation, such as no graven images, no Sabbath breaking, no vain oath swearing. And they unmistakably rest even the universally accepted prohibitions against murder and theft, for example, on the sanction of the divinity proclaimed at the beginning of the text. So even if you look at the secular or the universal parts of the commandments against murder, against theft, even that is by the sanction of God. And so even that has a religious spin to it. see. Let's see what else we got here. And they talk about the government may not favor one religion over another or religion over irreligion.
And that's a very important point,
Yeah.
right?
And that's been kind of an evolution of the interpretation, I think, of the Establishment Clause. They didn't really think about atheists when they wrote the Constitution. It was it started out as not favoring one sect of Christianity over another, and then it evolved to not favoring Christianity over Judaism, Buddhism, other religions, and then finally it's evolved to not favoring religion over non-religion.
Right, and the courts have had to recognize the evolution of American society, have they not? Early on, in the early history of the First Amendment, there was, in fact, very little representation from non-Christian religion in American society. Whereas now, the composition of the American populace has changed so much that even though Christians, or those of Christian heritage and background, may still be a large majority, other faiths and traditions are very much in evidence, and we have a much larger atheist, non-religious community than we had at that time.
Yeah.
And so what we're seeing from the court decisions is nothing more than a recognition of the change of society.
Yeah. And actually, the principle hasn't changed. It's just been applied to more and more people. Well, the opinion that I've been quoting from in this Kentucky case was written by Justice Souter, and he finishes it off quite nicely. He says, "We are centuries away from the St. Bartholomew's Day massacre and the treatment of heretics in early Massachusetts.
Right.
But the divisiveness of religion in current public life is inescapable. This is no time to deny the prudence of understanding the Establishment Clause to require the government to stay neutral on religious belief, which is reserved for the conscience of the individual."
Right, and that's an extremely important thought that harkens back to James Madison's remonstrance in Virginia.
Memorial and Remonstrance.
Right, Memorial and Remonstrance, that even if you regard religious belief as holy, as something that has to be protected, that can only be protected when there is a wall of separation between church and state, that it requires not only a strong free exercise clause, but a strong establishment clause in order to respect the rights of the individual.
Yeah. Justice O'Connor wrote a concurring opinion, and she kind of picked off where Souter left off. She wrote, "By enforcing the clauses, the establishment clauses of no establishment and freedom, by enforcing the clauses, we have kept religion a matter for individual conscience, not for the prosecutor or bureaucrat. At a time when we see around the world the violent consequences of the assumption of religious authority by government, Americans may count themselves fortunate. Our regard for the constitutional boundaries has protected us from similar travails, while allowing private religious exercise to flourish."
Right. I think that the wall of separation has just done a fantastic job in American history for maintaining civil order. If we look at the history of other parts of the world, we see enormous religious conflict in the Middle East, for example, even within Muslim governments, such as within Iraq now, the difficulties that they're having putting together a government simply because of factional fighting between Sunnis and Shias. If we look at Northern Africa, with the fighting between Christians and Muslims there, that the wall of separation has performed a wonderful function in preserving peace in the United States.
Well, I'll conclude this case with a wonderful remark by Justice O'Connor. She says, "It's true that many Americans find the commandments in accord with their personal beliefs, but we do not count heads before enforcing the First Amendment."
Hear, hear.
Yeah. Well, so that case in Kentucky was decided in favor of separation.
Right.
We move on to another case now.
Yes, Van Orden versus Perry.
Yes, this was out of Texas. And this involves a Ten Commandments monument, one of those big granite monsters, like 6 foot high. And they were being placed, all around the country about 40 years ago or so, kind of as a tie-in with the Ten Commandments movie and Cecil B. DeMille.
Right.
Well, Texas has one of these big monuments, and it's out in its Capitol grounds, and there are 17 other monuments out there as well. So basically, the Supreme Court in this case decided that that monument was okay. And they said it's part of it's a passive monument. It's not like in your face the way it was in the Kentucky courthouses. So it's kind of passive. It's just kind of out there. You can walk by. You don't.
I personally find that argument less convincing.
Exactly.
Right.
But that was kind of one of their arguments. That it was part of a larger display of many monuments, so that helped to secularize it.
Right.
And that it had been there for all these decades and nobody had complained. And I take that as saying, well, if you break the law long enough and don't get caught, it's okay. I think that's a lousy
Right. The argument, as I understand it, was that because no one had objected for so long, that showed there was general acceptance of its secular nature.
Yeah. And of course,
strange.
You know, try objecting to a Ten Commandments monument in Texas. I mean, there's justifiable fear for your life if you do that. So I think it's a very poor argument. But anyway, that's...
But didn't the lower courts say, and the Supreme Court agree, that there was a valid secular purpose in putting the monument up, and that the state of Texas, in creating this array, this monument garden they have, honoring the Texan identity, was honoring the Eagles for their struggles against juvenile delinquency?
Right. That was the purpose of the monument. The Eagles had done a good job combating juvenile delinquency, and they wanted to put up a monument to honor them. Well, had they put up just a plain monument saying, we recognize and honor your work, no problem. But putting up this religious monument, that's the problem. It's not honoring the Eagles. That's not the problem. It's endorsing religion was, in our opinion, the problem.
Right. Well, I agree with you, certainly.
Yeah.
But trying to understand the position that the court has established, they found that in the Kentucky state capitol case, that the monuments are legal, first off, because no one had objected for so long, and secondly, because they don't have the legislative trail that they found in Kentucky that showed that their intent was to honor religion. So this seems to mean that it's okay to put up the Ten Commandments monuments if you don't really mean it, if you don't say anything about it, and that if you're opposed to the monuments, you have to complain immediately and loudly.
In the dissent in this case, written by Justice Breyer, he said, the message transmitted by Texas's chosen display is quite plain. This state endorses the divine code of the Judeo-Christian God. So he would have agreed with us. He said, the adornment of our public spaces with displays of religious symbols and messages undoubtedly provides comfort, even inspiration, to many individuals who subscribe to particular faiths. Unfortunately, the practice also runs the risk of offending non-members of the faith, being advertised, as well as adherents who consider the particular advertisement disrespectful. So in other words, you could put up a religious display, and even people who believe in it might find it offensive because they might find it too gaudy or not like it in a secular setting. So that would be another reason not to have a religious display.
Might mention, although it wasn't part of the decision here, but there is a reason for religionists, for Christians, to object to Ten Commandments displays because they're divided on what the Ten Commandments are. The Catholics have one version in which they divide the commandments up in one way, and Protestants generally divide them up in a different way.
Well, and Justice Stephen does address that in the dissent. saying that there are at least 3 different versions of the 10 Commandments, and by the state picking this one version on the monument, it's endorsing that, and it's taking a theological stand, which it's not permitted to do. It's always nice when atheists are recognized in Supreme Court decisions, even though in this case it's in the dissent. Let's see. He says, the Establishment Clause requires the same respect for the atheist as it does for the adherent of a Christian faith. So that's nice. Individual freedom of conscience, protected by the First Amendment, embodies the right to select any religious faith or none at all. And there are some conservatives that say freedom of religion is only freedom to choose which religion you want.
Right.
But of course, true freedom, you have the option to say none of the above and none at all. That's full freedom. And that's what this country's supposed to stand for.
Yeah. Why don't we talk for just a moment about the opposing views that Rehnquist and Scalia and Thomas have of the First Amendment. Now, Scalia has said that the First Amendment does not bar the endorsement of religion as opposed to irreligion, the exact opposite of the majority opinion that we saw in the McCreary County case. So the rulings really seem to be in conflict on that point.
They really are. I mean, this seems almost like 2 political decisions, to make some people happy and others not happy, and then flip it the other way. You've already touched on some of the problems with these conflicting rulings. These rulings don't address the case of where you have the monument on public grounds, but there are not all these other monuments. It's just that monument. They didn't address that. This was the case in Duluth, Minnesota, for example. And there it was moved to private property. It doesn't address the case of, well, what if we establish a new set of monuments, and one of them is the 10 Commandments. They are inconsistent here. Right.
And then the scariest of the justices is Thomas. And Thomas has objected to stare decisis. He doesn't want to be bound by earlier decisions that he considers to be erroneous. He wants to just review everything and throw everything out with which he disagrees. And Thomas's stated view of the First Amendment is that the First Amendment bars Congress from interfering with any establishment of religion that the states create, which would totally turn interpretation of the First Amendment on its head.
Right, but he's ignoring the history of the First Amendment. I mean, it was meant to go both ways. Presidents like Thomas Jefferson refused to proclaim a day of Thanksgiving, and that's mentioned in these court cases, because it violated separation of state and church. James Madison's famous memorial and remonstrance, saying how the separation protected both the government and religion, a masterpiece even today. So I think you have to look at the Constitution as a living document. You have to interpret separation in light of the facts as they exist today. I think the principle has stayed the same, and it's just been applied to more and more people. Some people have said that that is kind of the trend of civilization, that rights are conferred upon more and more people. Let's face it, when this country started out, it was property-owning white male adults. Okay, right. They had and everybody else, So
right.
Gradually, people of minority races, women, blacks, gays, atheists were gradually getting equality in our rights.
Right. For about the last 50 or 60 years, the Supreme Court rulings have been pretty consistent in First Amendment cases. But whereas we used to get a decisive Supreme Court majority, now we're seeing 5-4 decisions teetering. And Justice O'Connor has announced her retirement, and Roberts has been appointed and has
Nominated, yeah.
been nominated by the President, well, been appointed by the President, but is awaiting confirmation by the Senate. And what effect do you expect that to have on the wall of separation?
O'Connor had taken a pleasant turn towards separation. She was against both of these Ten Commandments displays, which was a pleasant surprise. From what I've read about Roberts, I don't think he's going to expand any rights to further this progression of civilization. For example, when I look at the 14th Amendment, equal protection under the law, to my mind that means gay people deserve equal protection, and so they deserve equal marriage rights. I don't think he's going to go there. I don't think he's going to acknowledge that. On the other hand, he seems to have respect for precedent, and I don't, or at least I certainly hope, he's not going to roll back any rights that we've currently achieved, the right to choice in abortion, the right to contraception. I don't think he's going to roll those back. So best case, we'll have kind of a status quo until another progressive judge wants to get in there and look at the Constitution as a living document.
Before the Supreme Court decisions, there was a headline that was run, I believe it was on The Onion, predicting the outcome. And it said, Supreme Court reaches split decision on 10 Commandments, upholds 5, overturns 5. And the actual decisions, I think, are pretty close to that, in that rather than clarifying anything, it really seems to have muddied things. It does help us clearly in a number of ways, that we can now look at intent and have monuments ruled unconstitutional because it was the intent to support religion. But by issuing split decision, I think it's really inviting future litigation in more cases. What's your opinion on that?
Yeah, this has only settled a few things. I think it's pretty well set that they're going to take a harder stance on separation in schools. They've kind of reaffirmed that. That was the 1980 Stone decision of Ten Commandments plaques in public schools. They reaffirmed that they will take a harder stance in those areas. And like you say, they will be looking at intent, so we can hope for the best there. It's funny you talk about a 5-5 decision on the commandments. Actually, only 3 commandments have counterparts in secular law. Murder, theft, and lying, but that would be under oath. Most commandments have no application to secular law.
Well, that's right. I want to thank you, August. We're out of time now.
Oh, okay.
But this evening, this discussion has just raced by. We're Minnesota Atheists. Our contact information has been on the screen frequently throughout this program. And if you contact us, we'll be glad to send you a free issue of our newsletter, of which August is the editor. And so we would really enjoy hearing from you. If you're interested in us, we're interested in you.